The Ghislaine Maxwell case is moving forward in court because it's federal. We can't see it. No audio or video or pictures allowed. So instead, let's go to the court docket. These are the minute entries that we can pull from the federal court out of the Southern District of New York. And let's bounce around and take a look at what's happening on November 22nd. Very busy day in court. So you can see here we have an order as to Ghislaine Maxwell. They're going to hold a final pretrial conference on November 23rd, 9:30 a.m. So we'll certainly cover that court proceeding after when we cover on the November 23rd docket, so in the next video. Then we had on November 22nd another memo, an endorsement, as to Ghislaine Maxwell about a prior issue. Parties respectfully submit this joint letter to request video monitors with a live feed to the trial proceedings in each of the counsel's rooms. It says, to the extent that the government is requesting that a video monitor be provided in a counsel room, the request is granted to the extent the district executive can accommodate their request. If the government is requesting a video monitor in its own offices, that request is denied. So they were fighting over access to the live feed of the trial proceedings. The government wanted it sort of ported in a number of different locations so that both teams could dive in. We can see this is the court order from, no, this is not the court order. This is defense lawyer Christian Everdell, who is representing Ghislaine Maxwell, but the judge just entered the order right on top. So he proposed this, and I think we covered this in a prior video, but the judge is now saying exactly what we read. Government is requesting provided in counsel room. That is no problem. So it can go over to counsel room at 40 Foley Square, but it cannot go into the government's own offices. So we see that Judge Alison Nathan issued that order. So we can close back out of that one. We'll go back over here. What's the next order? So we have another order, 1122. The court is in receipt of the government's proposed redactions to the parties' supplemental briefing in the court's memo opinion. Now, this is where they're talking about the admissibility of anticipated witness number 3. Don't know who that is. The parties, according to the judge, are now ordered to file the redacted papers on the public docket same day. So they did that. Another entry. Letter motion addressed to Judge Alison Nathan. This is coming from the prosecutors, Maureen Comey, Allison Moe. Let's take a look at this one. And so here, this is a motion to quash the defendant's Rule 17 subpoena. Okay, so we covered this previously. We made a video here on this channel about this. And this was, I believe, the subpoena that was going out to the Epstein Victims Fund Foundation. So recall that when Epstein was being prosecuted, I think in the first event, they set up this compensation fund for victims of Jeffrey Epstein. If you got abused by him, you fill out this claim, you submit it over to the Victims Compensation Fund, they vet it, they give you compensation. They give you money in exchange for your signing of non-disclosure or whatever they want from you. So they go through this process. The defense team here for Ghislaine Maxwell, they're saying that's very pertinent information. Any of these alleged victims that are making the accusations in this case, if they were compensated through that victims fund, we want to know about that because that might show that they're very biased and that they are prejudiced. They've been compensated, and part of that compensation is signing of documents and transferring information. The defense team wants all of that information because what they want to say is that these parties were biased into making claims against Ghislaine Maxwell predicated upon them receiving compensation. If they can make a valid claim against Ghislaine, well, then they can use that valid claim, that prosecution, to show the victims fund that this is a legitimate claim and then get compensation for that. They can say, we're not making this up. Look, there's a criminal prosecution that's actually moving forward. That's what justifies us receiving compensation. So that subpoena went out. We covered that in a separate video here. And now we know that the government was going to move to quash that subpoena. Ghislaine's attorneys said that they wanted this to go out to the purveyor of the Epstein's compensation fund, the person who's in charge of that. They want information delivered from her back over to the defense so that they can vet it, so that when the government calls these witnesses up on the stand, they can say, well, you got $1 million, didn't you? And you were compensated, so you have an interest in furthering these allegations. Otherwise, why'd you get the $1 million? If you weren't actually the victim, then maybe you were not entitled to that $1 million. So they're going to be using it as impeachment evidence in a whole multitude of different ways. But we can see that the government is now seeking to quash that. They do not want the subpoena to go out. They're saying the defense has informed the government they don't want redactions on that. The government does have proposed redactions on the motion. And so what they're doing is they're notifying the court. They're saying, we've got a motion that's coming. We're going to have to redact a bunch of stuff on it. The defense doesn't want any of it redacted. And so we have to have a conversation about that, Judge. What do you think about it? So we go back over to the docket. We saw what that letter looks like. We have another one also going to the judge from the prosecutors. Let's take a quick look at this one. This is the memo about the motion to quash the defendant's Rule 17c3 subpoena for Jordana Feldman, the administrator of the Epstein Victims Fund. So this is the legal substance as to why they think that motion is invalid, why the subpoena should be quashed. And so you can go through that in further detail. We covered the defense motion as to why they want the subpoena, but here they're responding saying that they're trying to say why it's not admissible. As you can see, the defendant also argues that the records contain prior statements. They're saying this argument misses the marks. Any statement in their files are unlikely to be inconsistent in light of the context in which they were made. I think this is going to get granted. I think the judge is going to grant it. And in fact, even Jordana Feldman's attorney submitted a letter and said, well, we expect this to be granted, and so add us to the docket, in other words. Signed off on here by Maureen Comey, Allison Moe, Lauren Pomerantz, Andrew Rohrbach. We've talked about those. Those are the prosecutors that we covered in the prosecutors video here on this channel. All right, let's see what else we've got. Told you, very busy day. Another letter to the judge sent over. This is about the authentication of the birth certificate. So this is an interesting issue here. Let's take a look at what's going on. Dear Judge, the government says we respectfully submit this letter about the birth certificates. By way of background, the government has obtained and produced the defense certified copies of the birth certificates for each of the minor victims. Remember, if they're going to be saying that Ghislaine is trafficking in minors, they got to prove that they're actual minors. They can't just say, well, she looks young, so that qualifies. No, they got to prove it. They say she was born in 16 years ago or 17 years ago from the date of the offense, right? They do the math. They say, look, birth certificate is here. The allegations only took place 16 years after this birth certificate, meaning she was 16, meaning she's a minor, meaning that's trafficking minors. Although the government has asked the defense to stipulate to the authenticity of these records, and although the defense has identified no reason to doubt the authenticity of these records, the defense has not agreed to a stipulation. Accordingly, the government seeks relief in the instant motion to which it is entitled under the law to avoid calling records custodians from 5 state agencies with custody over the birth certificate. So a couple things are happening now. One, the government, they need to prove this element of the case. What they're asking the defense to do is to just agree to it, to just say, look, you want to take a look at this birth certificate? It's legitimate. It came from Alabama. What do you think about it? Okay, it looks real. Do you agree it's real? Yes, it is. So we don't need to prove this in court, right? No, because we agreed to it. It's a stipulated agreement. We're going to admit it so that we don't have to go into the weeds about a lot of this stuff. The defense has said, we'll agree to it as long as you lay the proper foundation and you come up with these other necessities prior to us agreeing to it. So what the prosecutor is saying is, we're not going to want to agree to all those other things. So can you, judge, just allow us to handle this birth certificate issue right now? So they want to make their arguments here. You can see we're going to have a big redaction here. Looks like it's probably an actual copy of the birth certificate that they want to admit. They're saying each of these certifications is a certification by a custodian sufficient to satisfy the rule. And so the government is turning around and saying, we don't need to produce the actual custodian of the records because this certificate of authenticity satisfies the rules. And so they're trying to work through a lot of this stuff before they actually have to call their witnesses. They don't want to call Jane Doe, who was 16 at the time, and then have to get into the fight about the birth certificates. So the government is saying, we don't need to bring the person who actually signed the birth certificate or the official custodian of records from the states to prove this case. We just need a certificate of authenticity or something to those effects. And they're saying it's self-authenticating. Birth certificates comply with the rules for the following reasons. The court should determine that the minor's victims' birth certificates are self-authenticating. So arguing over the birth certificates, which is very important because if it's a minor case, got to prove it. All right, some other minute entries. Now we have a letter by Ghislaine Maxwell. This is addressed to the judge. This is about Government Exhibit 52. This is Ghislaine Maxwell's black book. We did a full video on this one. Let's see what this letter says. So on November 22nd, we see that a letter comes out from Hayden Morgan Foreman. This is Jeff Pagliuca, and this is Laura Menninger's firm. You can see them here. Jeff Pagliuca wrote this letter, very short, 3 pages, says, Judge Nathan. And remember, Exhibit 52 is all about the black book. This is Ghislaine Maxwell's contact book, which was allegedly sort of stolen from Jeffrey Epstein's property that has a lot of very important contact information in it. Dear Judge Nation says, there are 2 fundamental flaws with the government's evidentiary proffer regarding 52. First, as a matter of fact, Government Exhibit 52 was not something that the cooperating government witness reviewed, used, or saw during her employment with Epstein. Records produced in discovery reflect that witness began working for Epstein in some year. Redacted, don't know. At that point, the suspect's source of Government Exhibit 52, Alfredo Rodriguez, was not employed by Epstein because he had been fired. So remember in the Exhibit 52 video that we covered that the allegation was that Alfredo Rodriguez, somebody was actually sort of a servant of some kind for Epstein, somebody who was there doing something on his property, saying that he actually took the black book and then allegedly pled guilty to taking it and then somehow ended up dead. If you missed that video, watch that one for sure. According to Mr. Rodriguez, when he left the Epstein home, he took an address book, which he claimed was Epstein's book, and had it in his possession until 2009 when he tried to sell it to Brad Edwards for $50,000. The book was clearly altered by Mr. Rodriguez, so it's not reliable, is what they're saying. Footnote, Mr. Rodriguez knew the target of his intended sale, which makes the likelihood of alteration all more probable. Mr. Edwards was a lawyer within Fort Lauderdale law firm of Rothstein, Rosenfeld, and Adler. The firm was under investigation by U.S. Attorney for the page that the government intends to offer. No, wait, no. Okay, so let's carry on. That footnote says U.S. Attorney for the Southern District of Florida that involved falsifying documents, specifically against Epstein, blackmailing targeted defendants to settle false allegations of sexual harassment. Okay, so the book was altered by Mr. Rodriguez. The single page that the government intends to offer has various handwritten notations on the copy, so somebody modified it. The book, as an entire document, contains numerous handwritten notes, added tabs, additional handwritten pages. The government does not explain how the one selected page is authentic and does not identify any rule for the basis of that testimony. They say the evidentiary proffer offered by the government. So what they're talking about is the government is telling the court, this is what Exhibit 52 is. We can't really show you it. We can't really explain everything that's in it, but we're going to tell you a little bit about it. We're going to give you an evidentiary proffer. We're going to kind of give you an overview of the evidence so that we can talk about it. And then, judge, we're telling you that these things are true. We're telling you that Mr. Rodriguez did this, that, and the other with this black book. So if you trust us, then you can make a ruling based on that proffer. And so the defense is responding and saying that proffer, what they're asking you to base your ruling on, it's pretty bad. In fact, there's all sorts of problems with this document, with this book. It's got notes on it. It's got tabs in it. It's been, thrown in somebody's gym bag for a long time. It's very unreliable. They continue. It glosses over what limited facts the witness may have actual knowledge about. Did the witness see copies of the address books in the residence beginning in this year? She cannot say that Exhibit 52 was one of those books. She can't comment about the alterations made by Mr. Rodriguez. No other address book to compare it against. Other witnesses dispute the characterization of the books as proffered by the government. Jeff Pagliuca says, the party offering an exhibit must demonstrate, quote, evidence sufficient to support a finding that the matter in question is what its proponent claims. This is the proffer. The government is saying, we have Exhibit 52. It's Ghislaine's black book. And we say, yeah, but how do we know that? And the government says, well, Alberto Rodriguez and all of these other things. The defense is saying, no, I don't believe you. That's not any good. The requirement is satisfied if it is sufficient proof has been introduced so that a reasonable juror could find in favor of authenticity or identification. Here they say government fails. In other words, they're saying there's no reasonable juror that could believe that Exhibit 52 is real or authentic. As such, they're saying Maxwell respectfully suggests this issue cannot be resolved by the court without consideration of the evidence and the witness through whom the government will attempt authentication. So they're telling the court, we can't discuss this, we can't figure this issue out right now. We're actually going to have to hear from the witness, and that's why it should be precluded. Ms. Maxwell requests the government be precluded from discussing the book at trial prior to a proper evidentiary foundation being established. So they've got to be they're saying this government better be very careful about talking about this book without proper foundation. They're also asking the court to say that in addition, the government should be required to produce the entire book for inspection at trial. And counsel for Ms. Maxwell should be afforded the opportunity to conduct voir dire of the exhibit with the proffering witness. So in other words, got to do a deep dive on this Exhibit 52, according to the defense, before we can even talk about it or mention it. And we want to do a deep dive about where it came from and who touched it and how did it end up here in court. So that is Ghislaine Maxwell, her defense attorney. That was Jeff Pagliuca. Laura Menninger over from Hayden Morgan and Foreman. That was on November 22nd. You can see a lot of additional activity here. Let's see if there's anything else good that stands out. So we've got another reply about GX52. This is also by Ghislaine Maxwell's lawyers. Let's see what they're talking about here. So this is by the U.S. Attorney's Office. And so they're saying here, they're responding to her. They're now replying to the letter to exclude Government Exhibit 52. So we just got done reading Jeff's. The court ordered the government to respond, specifically saying that Employee 1 cannot authenticate the exhibit because Rodriguez removed the document before Employee 1 began working there. The defense is saying Employee number 1 can't possibly have known anything about it because it was gone by the time Employee number 1 got to the residence. Rodriguez already left. And he says that he removed the document when he left. He took it with him. So the government moves on. 6 pages. They cite something from the Second Circuit. They're saying that Exhibit 52 is unique in a way that is not supported by the evidence. They're saying that Employee 1 will testify that it appears to be a copy of the defendant's address book. She's going to testify that other bound sewn type copies of the same address book with the same cover were located in specific places in Epstein's house. They corroborate it with another exhibit, 606, the household manual. When you have an estate, you have to have a manual for the estate, which states that a copy of Mr. and Miss Maxwell's telephone directories must be placed to the right of each telephone, except for guest rooms. So the estate manual says that they posted this stuff all over the place. It's also corroborated by Rodriguez himself, said the prosecutors. So Employee 1 observed the contact book in close temporal proximity to Mr. Rodriguez's departure. So even if Rodriguez left before he got there, the house manual still said that it was supposed to be this way. So Rodriguez did it according to the house manual. He left. He took one of the books with him. But whoever picked up after Rodriguez was there, presumably followed the manual. and put another black book right next to the telephone. So they're saying that employee 1 came up after that and was so close in time that it's basically the same thing. So who cares is what the prosecution is saying. It's so close. It's basically the same thing. Even if she technically got there after Rodriguez left, doesn't matter. Let's see. We have an example here. Or consider if the Yankees have distinctive team-branded water bottles spread across their locker room. A player who has seen the water bottles can authenticate one, even if the particular water bottle was taken from the locker room before that player joined the Yankees. Same case here. Consider if an employee gives a history of the firm book to each new employee. An employee who is aware of that practice and who starts in 2021 can authenticate a copy of that book even if the particular copy was given to an employee who started in 2020. Talking about the same case here. Authenticity does not require employee number 1's testimony. We have some more redacted paragraphs here. The defense is correct that employee number 1 cannot say that she saw the specific address book while she worked, but she can recognize one of many copies that she did see. She can testify that when she left the house, it was regular practice to keep those documents in those places. So they're asking that the court, the testimony is enough to satisfy the low bar for authentication. It's supported by Exhibit 606. And so they do not want the court to preclude them from talking about Exhibit 52. We'll see what the judge says about that. We've got more minute entries from 1122. Letter by the USA to Ghislaine. A supplemental letter, re the Witness 3 document. So we already covered Witness 3, so we'll skip that one. Letter by the USA as to Ghislaine Maxwell. Witness 3 in definition of a victim document filed by the USA. Let's take a look at this. Okay, so this is another government motion. Respectfully submits this letter in further opposition to the defense motion to exclude evidence of minor victim 3. Looks like they discussed this previously. As set forth in greater detail, minor victim 3 is direct evidence of the offenses charged. So factual background, government expects minor victim 3 to testify in substance and in part. She met defendant in 1994 when she was approximately 17 years old. Redacted, 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 redacted. Okay. Then we get to applicable law. And, a lot of that is relatively boring. Evidence relating to minor 3's testimony is direct evidence of the conspiracies. So this person was directly involved in it. As the government argued in its motion, evidence of minor 3 is direct evidence of the Mann Act conspiracies. Defendant's conduct with minor victim 3 overlaps in time and place with the other minor victims. 1994, 2004, New York, massages, Palm Beach. The government expects the defendant's relationship with Epstein to be a critical factual dispute. Specifically, whether that relationship included conspiring with him and aiding or abetting Epstein's sex crimes. Evidence about minor victim 3 also, quote, fills a narrative about, quote, why the defendant took actions to arrange the massages. Then we get a big redacted. The fact that minor victim 3 was above the age of consent in relevant jurisdictions has no bearing on this analysis. Evidence about minor victim 3 is also direct evidence of the trafficking counts in the indictment. Rule 404B, talking about whether this is relevant for multiple purposes. It's relevant to the knowledge. The government anticipates that minor victim 3 is going to describe redacted, huge paragraph of redactions here. Evidence related to minor victim 3 is similarly relevant to the Mann Acts. Evidence that Epstein had a sexual preference for women much younger than him, including 17-year-olds, is probative of whether he had a sexual preference for 16-year-olds. Blank, 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 redacted. Probably so-and-so was 16 at the time. Second, the evidence is relevant to the defendant's motive. The government expects the defense to argue the defendant had no reason to assist Epstein in obtaining these massages. Minor victim is going to testify contrary to that. Redacted, redacted, redacted. Talking more about intent. Minor victim 3 will testify redacted. Defendant identified minor victim 3, befriended her, and invited her over. Now talking about Ghislaine Maxwell. big paragraph or big sentence redacted. All this happened during the conspiracy. So you can see a very big substantive document, Rule 403 they mention. And then it's signed off on here. Let's see, closing paragraph. If the court were to give such an instruction, the government would, let's see. An instruction that the defendant's conduct was illegal at the time would seriously risk misleading the jury. If the court gave an instruction, the court wants to make sure the jury understands its point. The instruction should say that minor victim 3 was above the age of consent at all relevant times, but it should also say expressly that the jury can consider her evidence as direct evidence or for all the permissible purposes under Rule 404. Then as a result, and the admission of her testimony is entirely proper. So submitted here by Alison Moe. Very big substantive motion about minor victim number 3, her testimony, and really about her age is really what that came down to. Back to the minute entries. A few more here we can see. A letter by Ghislaine. Let's see what this is. So Ghislaine's attorney, Christian Everdell, submitted this. No, this is from, yes, this is from him. On behalf of our client, we submit this letter about excluding evidence about accuser number 3. The government's November 7th letter in response to the court directed the government to state its position as to whether this anticipated witness could be deemed a victim of any crime charged in the indictment for any legal purpose. So they go through, they want to argue it's a big motion, so 12 pages. Final argument. The court ruled that accuser 3 could not be considered a victim of the crime charged in the indictment, and that they cannot refer to her as victim or minor accordingly. There is no need for the defense to respond to the government's November 7th letter. So basically, it looks like he's saying that this has already been decided. And he's going through this, and he's actually going through the transcript of the prior court proceedings about what happened, what it looks like. Also says accuser number 3, evidence is not direct evidence of any crimes. The government devotes only a single paragraph to explaining why accuser 3's evidence is admissible as direct evidence of the trafficking. Few reasons the government does give are meritless. Government starts by asserting accuser 3 evidence is admissible to prove the trafficking conspiracy. Court has already rejected those reasons. The government then makes a puzzling assertion that accuser number 3's evidence is admissible because it demonstrates the reason for participation in a conspiracy. These arguments are misguided, unpersuasive. Neither of the two specific bases for admission speaks to the reasons for Maxwell's participation. Also, they're legally and factually flawed. As to the issue of compensation, redacted, redacted, redacted. So we'll see what the judge has to say about that. We've got two different opinions from both attorneys. And then we have an order. We see the court will send the temporarily sealed memo opinions and orders to the parties. By November 24th, the parties are ordered to inform the court whether they're going to be sealing or limiting redactions in the memo. File any of those proposed redactions. So we've got another order coming. Right now, the judge is sending them back to counsel for proposed redactions. And then we have 496, a letter motion to the judge from the U.S. attorneys. We get an order about that. The court is in receipt of the government's, Feldman's, and the two anticipated motions to quash the defendant's Rule 17. The motion to quash denied. Ooh. Right, and that's what we just read that, I think, at the start of this segment. Been reading a lot of Ghislaine Maxwell stuff, but here is what the court said. Judge Alison Nathan, the court is in receipt of the objections to quash the subpoena, denied. Court orders Epstein's Victims Compensation Program to produce to the court via electronic thumb drive any materials responsive to this subpoena as soon as possible. So November 24th is going to be their deadline for that. Upon receipt, the court will determine whether the parties may inspect all or part of the materials. Parties shall negotiate a protective order and submit the proposal for approval by the court no later than 12 p.m. Administrator Feldman's request for oral argument is accordingly denied. So they asked to be heard on this objection. Judge has ordered that all those documents are going to the defense. That's going to be very interesting to see what is in there. Ooh, very, very interesting. So all that is happening. Now let's see. That was the final order for the docket on November 22nd. And so we'll pick back up on 11/23. And a reminder, the reason we do this is because oftentimes a lot of the dockets are not updated until the following day afterwards. They trickle in late. So 11/23s, we really don't know what all is on 11/23, usually until we get to 11/24. And so we're sort of going to be a day behind on the docket updates, but we're going to continue to cover the Ghislaine Maxwell case. We're going to go through the docket like this. These documents are all available publicly on the Recap archives. So if you type in Recap archives on Google, you're going to see something that looks like this. It's called Court Listener. It's at courtlistener.com. And if you go there, you can find Ghislaine Maxwell, and you can actually read the full documents in their entirety if I skip through them a little bit too quickly. But stick around, subscribe. Definitely let me know if you like this video, if this is useful. I know with Ghislaine Maxwell, there's nothing to watch. There's no audio to listen to. So it's kind of the only way we can follow along what's happening in the case. So if you like this video, if you like this type of content, this a little loose format of going through the docket, let me know and we'll continue to do it. Otherwise, I will see you on the next one.